Why is it a crime to refuse to comply with a breathalyzer test in Canada? There's actually a really good reason for this. I mean, it makes perfectly logical sense if you think about it. People who are impaired or drunk or over the limit and they know they've had too much to drink to drive often still do it anyway, right? Alcohol impairs your judgment, so it makes you make bad decisions. That's why we have laws about drinking and driving, to try and deter people, but they're not perfect, and that's why we continue to enforce them and violate charter rights for the purposes of that enforcement. But why make it a crime to refuse to give evidence prior to speaking to a lawyer, prior to your opportunity to contact legal counsel? It is to allow police to engage in that detection. We have what is called Section 1 of the Charter in Canada, which is essentially a provision of the Charter that allows the government to violate your charter rights if they feel like it, as long as that violation, that limitation on your charter rights, is justifiable in a free and democratic society. And the court will do an analysis anytime a law is challenged to determine whether or not the law itself violates the charter rights. So they look at whether it's proportional, whether it's the least impairing measure, and they balance all of these things to determine, I'm not going to get into the Oakes test, that's a separate video, but they look at all of these things to determine whether or not it's justifiable. And for when it comes to creating an offense about whether you can refuse to comply with a breathalyzer, it's justifiable because the need to detect and deter impaired driving is greater than the need to make sure that you get to talk to a lawyer before you make a decision about whether or not to blow. Plus, of course, as we know, ignorance of the law is no excuse. And so you should know, if you're driving, what the rules are in relation to the driving, including your obligation to comply with a test for a roadside breathalyzer before you get the opportunity to speak to a lawyer. Now, does this mean that it's always the case that you can't refuse? Well, that's the advice I will give you. Never refuse. But you can refuse if the demand is not lawful. The problem with this, of course, is that it's very difficult for you to assess the lawfulness of the demand yourself at the roadside. You're not a lawyer. I mean, maybe you're a lawyer, but most people are not lawyers. Most people are not police officers or like adjudicators or judges or whatever. Somebody with that specialized knowledge and training and skill to be able to understand all of the elements of a lawful demand. And the validity of demand is also determined by the court on review of the demand. It's not determined by you roadside. There's no roadside adjudication process to determine whether or not the demand is lawful, which is why the best advice is always to comply with it. Because if you don't, you get the refusal charge, and then you have to hope that you can successfully argue the demand was not valid. There was a successful case of this, though, coming out of the Saskatchewan Court of Appeal very recently this year. And in that case, it's called McCorriston. Mr. McCorriston is pulled over. The police officer takes his ID and then goes back to the police car to check it, to make sure he knows who he's dealing with, even though he'd already run Mr. McCorriston's plate at the time that he stopped him, so he knew whether there were outstanding warrants for Mr. McCorriston. He had an idea of who this guy was and that he wasn't a safety risk, but he went to confirm the identification before then asking him to provide a sample into the roadside breathalyzer. And when the officer walked back to Mr. McCorriston's car, but 5 minutes later, the officer said, "Hey, now I'm going to get you to blow into a roadside breathalyzer, so here you go, time to provide a sample." And Mr. McCorriston, who had just gotten off the phone, gosh, I wonder if that was a call to a lawyer, but we'll never know. He had just gotten off the phone, and he looks at the officer and he says, "No, I think too much time has passed." And he was right. The Saskatchewan Court of Appeal agreed that too much time had passed. Those little 5 minutes that the officer spent were not appropriate waiting, because the only delay that's justified in Canadian law is delay that's necessary for the operation of the equipment, or unusual circumstances that couldn't be predicted, like something really strange happens. You think about like an accident, somebody's bleeding out, that type of thing, right? Not something that the officer could control, chose to do instead of making a demand. So while Mr. McCorriston was right, he had to go all the way to the Saskatchewan Court of Appeal to be vindicated. He lost at trial. He was acquitted on appeal. So he had to pay for a trial. He had to pay for an appeal. That means paying for transcripts. And then the government appealed that, and he had to pay for everything at the Court of Appeal before he could be vindicated on this. That's why you should just blow. Because it's a criminal offense to refuse, you will be charged, and your opportunity to adjudicate the validity of the demand comes later. So why do we have refusal laws? To make it easier for police to investigate impaired driving. Why do we criminalize refusal? because there is a mechanism to detect whether or not the demand is valid later on through the criminal trial process, but it's flawed in that it's going to be expensive. It's going to take years sometimes out of your life, and you might not win.